Good day, everyone. Welcome to our presentation, the Barcelona Traction Light and Power Company Limited, Belgium versus Spain topic. I am Mia and my partner Ronan. Proceeding in the case concerning Barcelona Traction Light and Power Company Limited, Belgium versus Spain. Facts of the case, the Barcelona Traction Light and Power Company Limited was incorporated in 1911 in Toronto, Canada, where it has its head office. For the purpose of creating and developing an electric power production and distribution system in Catalonia, Spain, it formed a number of subsidiary companies, of which had their registered offices in Canada and others in Spain. In 1936, the subsidiary company supplied a major part of Catalonia's electricity requirements. According to the Belgian government, some years after the First World War, Barcelona Traction share capital came to be very largely held by Belgian nationals, but his contention was denied by the Spanish government. Barcelona Tractions issued several series of bans, principally in sterling. The sterling's bans were serviced out of transfer to Barcelona Traction, affected by the subsidiary companies operating in Spain. In 1936, the servicing of Barcelona Traction's ban was suspended on the account of the Spanish Civil War. After that war, the Spanish exchange control authorities refused to authorize the transfer of the foreign currency necessary for the resumption of the servicing of the sterling bans. Subsequently, when the Belgian government complained of this, the Spanish government stated that the transfer could not be authorized unless it were shown that the foreign currency was to be used to repay debts arising from the genuine importations of foreign capital into Spain, and that this had not been established. In 1948, three Spanish holders of recently acquired Barcelona Traction sterling bans petitioned to the Court of Rios, province of Tarragona, for a declaration adjudging the company bankrupt on account of failure to pay the interest on the bans. On February 12, 1948, a judgment was given declaring the company bankrupt and ordering the seizure of the assets of Barcelona Traction and of the two of its subsidiary companies. Pursuant to this judgment, the principal management personnel of the two companies were dismissed and Spanish directors appointed. Shortly afterward, these measures were extended to the other subsidiaries companies. New shares of the subsidiary companies were created, which were sold by public auctions in 1952 to a newly formed company, Fuerzas Eléctricas de Catalunya, which thereupon acquired complete control of the undertaking in Spain. Proceedings were brought without success in the Spanish courts by various companies or persons. According to the Spanish government, 2,736 orders were made in the case and 494 judgments given by lower and 37 by higher courts before it was submitted to the International Court of Justice. The court found that, in 1948, Barcelona Traction, which had not received a judicial notice of the bankruptcy proceedings and was not represented before the Rios court, took no proceedings in the Spanish courts until June 18 and thus did not enter a plea of oppositions against the bankruptcy judgment within the time limit of 8 days from the date of publication of the judgment laid down in Spanish legislation. The Belgian government contends, however, that the notifications and publications did not comply with the relevant legal requirements and that the 8-day time limit never began to run. Representations were made to the Spanish government by the British, Canadian, United States, and Belgian governments as from 1948 to 1949. The interposition of the Canadian government ceased entirely in 1955. The Belgian government filed the first applications with the court against the Spanish government in 1958. In 1961, it gave notice of discontinuance of the proceedings with a view to negotiations between the representatives of the private interest concerned, and the case was removed from the court's general list. The negotiations having failed, the Belgian government on June 19, 1962 submitted to the court a new application. In 1963, the Spanish government raised 4 preliminary objections to this application. In its first preliminary objections, which was rejected, the respondent contended that this discontinuance precluded the applicant from bringing the present proceedings. The secondary preliminary objection was also rejected was regarding the lapse of Article 17, Paragraph 4 of the Treaty of 1927 on the dissolution of the Permanent Court to which the article referred, thus questioning the jurisdiction of the International Court of Justice over the case. The third preliminary objection, which was joined to the merits of the Spanish government, was to the effect that the Belgian government lacked the capacity to submit any claim in respect of wrong done to a Canadian company, even if the shareholders were Belgian. The fourth preliminary objection, which was also joined to the merits, was to the effect that the local remedies available in Spain had not been exhausted. The first issue of the case is, does Belgium have the just standing to exercise diplomatic protection of shareholders in a Canadian company? The second issue of the case is, does Belgium have the right and jurisdiction to bring Spain to court for the actions of a Canadian company?
Alrighty, let's go over first the three general principles of this case. First, the concept of no absolute obligation. Second, the need to distinguish company from shareholder when it comes to municipal laws. And third, the limitation that diplomatic protection can only be exercised by the nation state of the company. Under the first principle, it was noted by the court that when a state admits foreign investments or foreign nationals into its territory, part of this admission includes the protection of the law and assumed obligations, as well as their treatment. This is not absolute, though, for in order to bring a claim arising from the breach of obligation in this case, the state must first establish its right to do. Under the second principle, we highlight the importance of the distinction between a company and a shareholder. The reason for this is because in municipal law, the concept of the company was founded on this specific distinction. In fact, only the company, which was endowed with legal personality, could take action in respect of matters that were corporating. More often than not, when a wrong is done to a company, it prejudices its shareholders. This does not mean, though, that they're both entitled to compensation. Whenever a shareholder's interests are negatively affected by an act against the company, that shareholder only has to go after the company for appropriate action. Any act infringing the company's rights does not carry with it the responsibility towards the shareholders, even if their interests were affected. This was generally accepted by municipal legal systems, which international law had to refer to. Thus, any injury to the shareholders' interests which resulted from an injury to the rights of the company was not enough to base a claim upon. If we follow this line of thought from the second principle to the third, it would aptly explain how diplomatic protection then is only ever exercised by the nation state of the country. So, when it comes to unlawful acts committed against a company representing foreign capital, international law authorizes, as a general rule, the nation state of the company alone to exercise diplomatic protection for the purpose of seeking redress. In fact, no rule of international law expressly conferred such a right on the shareholders' national state. Let's move on to the question on everyone's minds right now. If there's a general rule, there must be exceptions, right? Well, the court did consider the existence of exceptions to the general principles, for without the former, the latter might not essentially take effect as they are the commanding principles. Thus, the court had to first study two key situations. With regards to the first case, in this sort of plot twisty way, it was observed by the court that while Barcelona Traction had lost all its assets in Spain and had been placed in receivership in Canada, it does not entirely mean that the corporate entity of the company had also ceased to exist or that it had lost its capacity to take action. As for the second case, there was nary a contention to the facts that the company had been incorporated in Canada, had its registered office in that country, and had its Canadian nationality received general recognition. Not to mention the fact that the Canadian government had also exercised the protection of Barcelona Traction for a number of years. If at any point the Canadian government ceased to act on behalf of Barcelona Traction, it nevertheless retained its capacity to do so, which weirdly the Spanish government had not questioned. Whatever the countenance of the Canadian government may be at any given time, this primal fact could not constitute a justification for the exercise of diplomatic protection. A state could make a claim when investments by its nationals abroad, which form part of its national economic resources, are negatively affected in violation of the right of the state itself to have its nationals enjoy a certain form of treatment. However, in the case at bar, that right can only be born out of a treaty or a special agreement. Neither existed and was enforced between Belgium and Spain at that. In the interest of equity, a state should be able to protect its nationals, shareholders in a company which had been the victim of a violation of international law. The court considered that adopting the theory of diplomatic protection of shareholders had some looming repercussions. The court believed that it would open the door to competing claims on the part of the different states, which in turn would create this atmosphere of insecurity in international economic relations. In the case at bar, however, where the company's national state was able to act, the court was not of the opinion that justandi was conferred to the Belgian government. In its final judgment, the court took cognizance of the great amount of documentary and other evidence submitted by the parties and fully appreciated the importance of the legal problems raised by the allegation which was at the root of the Belgian claim and which concerned denials of justice allegedly committed by the organs of the Spanish state. However, the possession by the Belgian government of a right of protection was a prerequisite for the examination of such problems, and since no jus standi before the court had been established, it was not for the court to pronounce upon any other aspect of the case. Accordingly, the court rejected the Belgian government's claim by 15 votes to 1, 12 votes of the majority being based on the reasons mentioned. More often than not, when a wrong is done to a company, it prejudices its shareholders. This does not mean, though, that they're both entitled to compensation. Whenever a shareholder's interests are negatively affected by an act against the company, that shareholder only has to go after the company for appropriate action. However, if the shareholders were to seek aid from Canada in which the company is headquartered and given correct identity, a lawsuit could occur. Thus, an individual cannot bring a claim against a state since it is not given that authority. This case will be viewed as an excellent reference for cases dealing with organizations and sovereign immunity claims and how to correctly deal with them. So that ends our report. Thank you everyone for taking the time to listen to Mia and I. We hope that you learned something and that you enjoyed listening to us. Thank you.